Let's talk about the Privy Council of the United Kingdom, or, to give it its full name, Her Majesty's Most Honourable Privy Council. What is it? What does it do? Why is it honourable? And what makes it privy?
With all the recent activity and chatter surrounding the Vybez Kartel case and the focus now orbiting around the UK Privy Council, we believe it's imperative to inform our audience as to what the Privy Council really is and how it works. Because beyond all the hoopla and free the world boss cries, how many of us actually know anything at all, except the name of or regarding the Privy Council? If you are one of those, or just curious to hear the explanation, please stay with us until the end of the video, and while you're at it, feel free to give us a like and subscribe to the channel if you haven't already done so. Let's get into it.
The Privy Council. Officially His Majesty's King Charles' most honourable formal body of advisors to the Sovereign of the United Kingdom, and is the highest court of appeal for many Commonwealth countries. Among Caribbean nationals, it is almost impossible to win an argument on whether or not the Privy Council should be replaced by a regional court as the final court of appeal for many Caribbean citizens. In this presentation, we'll look at what the Privy Council is, or even the extent this seemingly omissions council has on the lives of millions of Caribbean citizens. While we periodically hear details related to the highest judicial court for many Caribbean nations, many of us fail to understand just how sweeping the powers are within the Privy Council and its impact on these Caribbean countries. We will roll back the curtains and unveil many of the aspects related to the Privy Council and its possible replacement, the Caribbean Court of Justice, as we answer, what is the Privy Council and how does it affect the people of the Caribbean? Please like, subscribe, and turn on the notification bell for our future videos. The full name of the Privy Council is the Judicial Committee of the Privy Council, and it is the highest court of appeal for many Commonwealth countries, as well as the United Kingdom, its overseas territories, crown dependencies, and military sovereign base areas. Established in 1833, the Privy Council was formed to hear appeals in civil matters and is the court of last resort for the entire British Empire, other than for the United Kingdom itself.
The history of the Judicial Committee of the Privy Council reflects the history of government and law in the United Kingdom.
It stretches right back to the Curia Regis, or the Royal Court of Norman times. This court carried out all the business of government, advising the sovereign on legislation, administration, and justice. But over time, with the development of the House of Lords, the House of Commons, and the courts system, the council gradually began to define itself as the place where individuals who wished to ask the sovereign to consider complaints about errors by the courts would try to bring their case. This made the council, in effect, the most senior appeal court in the land. It met in a building which became known as the Star Chamber, situated on the bank of the River Thames within the site of the current Palace of Westminster.
By the time of the Tudors, the council began to form two distinct bodies: a judicial court to deal with appeal cases, and an administrative council advising the sovereign on governing. Under the Stuarts, the council's court faced intense pressure from those who wanted to curb the powers of the king. Eventually, the changes during what is known as the Long Parliament of the 1640s removed the council's powers in England, but it retained jurisdiction, a power to determine legal questions over other countries governed by the Crown. A major fire in 1698 destroyed much of Whitehall Palace, including the Privy Council chamber, which had transferred there earlier in the 1600s. Hearings were moved to new offices nearby.
In the early 18th century, it was decided that all legal appeals from British-owned plantations overseas would be heard by the council. During the rapid expansion of the British Empire, the number of jurisdictions looking to the Privy Council as a final court of appeal grew to such an extent that in the 19th century it became necessary to create a statutory judicial committee.
With the creation of the committee came much clearer rules about the conditions under which appeals would be heard. This was formalized in an 1833 Act, which also set out its membership. Later acts enabled the council to appoint senior judges from some of the other countries to the Judicial Committee. The idea was that the committee would help create a system of common law for the widespread parts of the British Empire, while hearing each case within the legal framework of the laws of the country in question.
The committee's grandly decorated chamber and neighbouring offices had moved into a new building on Whitehall in 1827, designed by Sir John Soane. The committee's rooms later became part of a larger building constructed by Sir Charles Barry in 1845, which still stands today on the corner of Downing Street.
At this time, the committee heard cases from a wide range of sources. Ecclesiastical cases relating to church organisation and doctrine were referred to the committee from 1832 alongside appeals from the Court of Admiralty relating to the collision and salvaging of ships. Given the breadth of its jurisdiction, it's not surprising that a number of famous cases were heard by the committee during the 19th and 20th centuries. In 1832, it heard an appeal against the governor of Bengal by subjects objecting to the forced prohibition of the practice of sutti, where the wife of the deceased was burned alive on the funeral pyre with him. In 1932, it gave judgment on claims by a Canadian historian that a manuscript she sent to a publishing house was plagiarized by H.G. Wells in his book The Outline of History. And in 1961, in a case involving an oil spill in Sydney Harbour, it ruled that defendants who wrongfully caused loss only had to pay for the loss which was reasonably foreseeable. This principle has since been widely applied by other courts.
But the 20th century saw the tide turn for the extent of the committee's jurisdiction. By the 1920s, it said that people living on around a quarter of the world's land could potentially appeal to the committee. But in 1931, reflecting the greater freedoms being given to the countries which made up the British Empire, Parliament passed a law which enabled British dominions to withdraw the right of appeal to the Privy Council.
More recently, some Caribbean countries have similarly withdrawn the right to appeal to the committee by joining the Caribbean Court of Justice, a court of appeal launched in 2005 to serve states in that region.
Today, individuals in 27 current and former Commonwealth countries, UK overseas territories, Crown dependencies and military sovereign base areas still retain the right to appeal to the committee. The Judicial Committee still plays a role in interpreting the constitution of those countries which have adopted them, as it has done throughout its history.
The Judicial Committee consists of senior judges who are called Privy Councillors, and they are predominantly justices of the Supreme Court of the United Kingdom and senior judges from the Commonwealth of Nations, that is, former colonies of the United Kingdom. The panel of judges, typically 5 in number, hear a particular case, then report their decision. The roles and jurisdictions of the Privy Council are expansive, and it is impossible to cover all in a brief format. However, the Council has main duties which include formally advises the sovereign on the exercise of the royal prerogative, and as a body corporate, as King in Council, it issues executive instruments known as Orders in Council, which, among other powers, enact Acts of Parliament. The Council also holds the delegated authority to issue Orders of Council, mostly used to regulate certain public institutions. The Council advises the sovereign on the issuing of royal charters, which are used to grant special status to incorporated bodies and city or borough status to local authorities. Otherwise, the Privy Council's powers have now been largely replaced by its Executive Committee, the Cabinet of the United Kingdom. Certain judicial functions are also performed by the King in Council, although in practice, its actual work of hearing and deciding upon cases is carried out day to day by the Judicial Committee of the Privy Council. The Judicial Committee consists of senior judges appointed as Privy Councillors, predominantly justices of the Supreme Court of the United Kingdom and senior judges from the Commonwealth. The Privy Council formerly acted as the High Court of Appeal for the entire British Empire, other than for the United Kingdom itself. It continues to hear judicial appeals from some other independent Commonwealth countries, as well as Crown dependencies and British overseas territories. The Privy Council in modern times. The number of independent countries that maintain appeals to the Privy Council has been greatly reduced in recent years. If the Caribbean is excluded, there are only 4 countries where the Privy Council is integrated into the justice system. These are Brunei, Zambia, Mauritius, and New Zealand. Moreover, Appeals from Brunei are now limited to civil cases, and the authorities in New Zealand are now considering whether to retain or abolish the right of appeal to the Privy Council. Many see the Privy Council as a colonial holdover, which still chains many Caribbean countries to British colonial rule. This is not a new criticism. In 1903, a New Zealand judge, Edwards J., counselled the Privy Council against overturning decisions of trained lawyers who have spent their lives in the colony, who know and understand its genesis, its laws, and its customs, as they cannot hope to know and understand them. This is a common argument against the Privy Council, as foreign judges and advocates are much less aware and knowledgeable about the laws in independent countries and the practitioners of those laws. This can be seen in the sample of cases that do make it to the Privy Council. The most notable example is probably the case of dancehall star Vybez Kartel, who was arrested and imprisoned for murder in Jamaica in 2014. Vybez Kartel has long argued his innocence and has been fighting his conviction through the court system from the beginning, appealing his conviction all the way to the UK Privy Council, which has taken up the case and is expected to give a ruling in the coming months. Vybez Kartel and his lawyer claim there was evidence tampering during the investigation, which has led to his false imprisonment. Therefore, the Privy Council, which is based in the UK and has no input in the making of Jamaica's laws, has the right to review the case and the power to overturn his conviction in the matter. Why not abolish the Privy Council? With all the feedback and pressure to change the Privy Council as the last court of appeal, one wonders why so many Caribbean countries maintain the supremacy of the court. Well, one reason is that the process for abolishing the right of appeal to the Privy Council is not as straightforward as one would expect. In Ibraleb v. the Queen, a landmark case established in 1964, the Privy Council ruled that legislation creating independence did not extinguish the prerogative right to hear appeals existing before independence. In other words, gaining independence does not automatically remove the jurisdiction of the highest court of the legal system. Leaving the Privy Council requires amending the Constitution, and this has been seen when on various occasions, for example, when the independent Jamaica Council for Human Rights was blocked from moving an appeal to the Caribbean Court of Justice, the highest court of appeal for many Caribbean countries. The process of amending the Constitution is sometimes complex and varies from country to country. For example, Jamaica's constitution creates the right of appeal to the Privy Council. To change this would require both houses of the Jamaica legislature to pass an amendment to change this appeal right. In Trinidad, for example, the power to amend the constitution is different and requires an amendment to be supported in its final vote by 3/4 of the House of Representatives and by 2/3 of the Senate, not just by a majority, as is the case in Jamaica. In several other countries, the process of constitutional amendments involves a parliamentary vote plus a referendum to the people who must support the amendment by not less than 2/3 of the turnout. For instance, in the Constitution of St. Vincent and the Grenadines. So, as you can see, even if there was a desire to remove the Privy Council, the process to do so is a difficult journey.
Thanks for watching. Don't forget to like, share, and subscribe to our channel. Until next time, walk good.